Welcome to video 2 of 2 of Creative Foreclosure Solutions. Broad legal options are our strength. In the previous video, video 1, we had shown foreclosure options, including litigation, modification, negotiation, and bankruptcy. In this second video, we will review the foreclosure process and how we can help you through it. To recap, the Jones family are facing foreclosure proceedings against their family home. In the first video, we showed how the Joneses, a hard-working middle-class family, became challenged in this manner and how they found our law office and were introduced to the broad legal options offered by our law office's 4 departments, concentrating in litigation, modification, negotiation, and bankruptcy. We explained how each department brings special abilities to the table to help save the family home, and we compared our efforts to characters teaming up to defend a mythical castle. We explained how each department had a potential role to play in getting to a positive resolution. Litigation in the form of foreclosure defense avoided default and fought each phase of the foreclosure proceeding to buy time and leverage for potential resolutions. Modification of the mortgage loan and/or various other negotiated settlements with the lender, like short sales, short payoffs, and negotiated reinstatements, were those potential resolutions, but were within the lender's discretion, so they required skilled presentation, advocacy, and the right timing and circumstances. Bankruptcy offered an automatic stay which immediately stopped foreclosure proceedings and sales, and offered several possible resolutions. One of the bankruptcy solutions in Chapter 13 was a 5-year traditional catch-up plan, which potentially provided a certain solution as long as the arrears were not too high. In this second video, we will show that the foreclosure process could vary from case to case, but if it was properly defended and dealt with, the process could take several years, and during that time, the Joneses as the borrowers or the defendants would have opportunities to both defend motions and applications by the lender in the foreclosure litigation, and also opportunities to try to resolve the situation through modification, negotiation, and/or bankruptcy. I explained that the process could vary from case to case, but if it was properly defended and dealt with, the process could take several years, and during that time the Joneses as the borrowers or the defendants would have opportunities to both defend motions and applications by the lender in the foreclosure litigation, and also opportunities to try to resolve the situation through modification, negotiation, and/or bankruptcy. If a resolution is not yet possible, as in the case of the Joneses, the borrower is served with a summons and complaint, which we then need to litigate by either quickly answering or respond to with a motion to dismiss. We also seek discovery from the lender. After the lender files an RJI, the court schedules settlement conferences to try to see if a resolution is possible to avoid the continued litigation. We attend the conferences and seek to engage the lender's attorneys in modification or negotiation discussions. If the borrower's income improves significantly at any point, and if the arrears and other debts are manageable, a Chapter 13 catch-up can also potentially resolve matters. Assuming that after several settlement conferences that no resolution is reached, the court moves on to the middle part of the foreclosure process, where the lender engages in motion practice and we would litigate to oppose their motions and bring our own cross motions. The lender's first motion, a motion for summary judgment, is a substantive motion that tries to show that there are no material factual or legal issues and that no discovery or evidentiary hearings are needed. We oppose and cross-move by trying to show the opposite, that there are material issues of fact or law that preclude summary judgment. If we prevail with showing that the lender lacks in the required proof, not only is the lender's motion denied, but the action may also be dismissed. If, on the other hand, the lender prevails and the court grants summary judgment, then we could either try to re-argue or appeal, or try again to resolve with non-litigation options such as renewed efforts to modify or negotiate. Next, the lender would serve us with a notice of computation, which we could oppose and ask the court for a referee hearing to dispute the amounts owed. The next step is that the lender moves for a judgment of foreclosure and sale, which is a technical motion where the lender tries to show that it has moved in a procedurally correct manner throughout the foreclosure. Again, we oppose and cross-move, and again, if there is ultimately a decision in favor of the lender, we can re-argue or appeal or again seek non-litigation resolutions. If the lender prevails on their second motion and obtains a judgment of foreclosure and sale, we move on to the last part of the foreclosure process, where the lender tries to sell the property at a foreclosure sale, which is a scheduled formal auction announced by a notice of sale. The borrower usually tries to stop the sale of its property either through an emergency order to show cause in Supreme Court, or before the appellate division seeking a discretionary stay, or by filing a bankruptcy case to obtain an automatic bankruptcy stay. The borrower can usually stop several foreclosure sales in this manner and gain time to seek a resolution. Even if a foreclosure sale eventually goes forward, we always have options to improve your situation and could try to prevent a closing by the high bidder by showing procedural defects and notice improprieties. Alternatively, if the closing on the referee deed does take place, we can continue to defend our client in eviction defense to protect our client for a while longer. Fortunately for the Joneses, our foreclosure defense efforts slowed down the foreclosure process for several years while the Joneses were still going through financial challenges. The foreclosure process nearly reaches a sale until it is stopped by an emergency order to show cause. This buys time, but not enough. Another sale is then scheduled 6 months later and is stopped by a Chapter 13 case with loss mitigation. The combination of our leverage and Mr. Jones's income improving with a promotion and Mrs. Jones going back to work allow the Joneses to finally get a modification. The Jones family is happy and secure in the knowledge that their home is theirs with the help of our firm. Would you like help from our talented attorneys who are willing to get in the trench with you? Contact us today. Enjoy our song.
When your home is on the line and your heart is filled with fear, there's a hero you can find to defend what you hold dear. With our every ounce of might, we'll defend your home's every right. We'll fight with swords, we'll fight with spells to protect your castle's bells. Brave legal team will stand with you through thick and thin. We'll unsheath our swords and take command to ensure your victory win. With our every ounce of might, we'll defend your home's every right. We'll fight with swords and fight with spells to protect your castle's bells. Junior can go to college and Princess Jones can wed. Papa and Mama Jones can embrace and sleep soundly in their bed. When we stop the monster, we shall sing and dance. Another home saved, and it was not by chance. With our every ounce of might, we'll defend our home's every right. We'll fight with swords and fight with spells to protect your castle's bells. The law office of Ronald D. Wise will be your beacon in the night. With our attorneys, wise and true, we'll fight for your home, for you.